Today we are discussing the concept of secession. As you are well aware, in the syllabus of NCA, under the basic concepts, amendment procedure and secession is the part of syllabus. Amendment procedures we have already discussed. Today we are discussing the secession. Secession is as such not defined or explained in the Constitution of Canada. Then what is the meaning of secession? Secession means an action or an act to leaving formally from the membership of federal organization. In other words, to understand this, a province has decided to move formally from the dominion amounts to secession. So meaning thereby that province is ceding from the dominion. There was a issue primarily with one province in Canada. As you are well aware that when the efforts were made to make the Dominion of Canada and the provinces independent from the Westminster, finally Canada Act 1982 was passed. But prior to that, the province of Quebec raised the issue and not accepting the proposal of Canada Act. A referendum was held for an independent political and economic sovereignty. The voters of the province of Quebec were asked to vote in favor of that issue by way of referendum. The referendum was held on 20th of May 1980. The voters were asked to vote in favor of the issue of political and economic independence. This referendum failed by way of a very narrow margin. 59.5% of the people, that is, voted for not leaving, or we can say against the referendum, and 40.5% were in favor of the referendum, or the question put to them that they are ready to have their own economic and political sovereignty. So meaning thereby after this referendum failed, the 1982 Act was finally passed by the Parliament of United Kingdom, and the Canada became independent in its constitutional issues as well. Meaning thereby the Canada Act 1982 came into force. Now the Canada Dominion or the provinces have not to seek the approval of the amendment of the Constitution of Canada. The Constitution Act 1982 as a schedule with the Canada Act 1982 came into force. The BNA Act 1867 was also renamed as Constitution Act 1867. But that political issue in the province of Quebec did not end. Again, an effort was made to ask for a referendum. The referendum was held again on October 30th, 1995. Again, this referendum, the issue was, I'll just read that issue for your understanding. Quebec should become sovereign after having made a formal offer to Canada for a new economic and political partnership within the scope of the bill, respecting the future of Quebec and of the agreement signed on June 12, 1995. But this referendum also failed by way of a very narrow margin, that is 50.6 were against the referendum, 49.4% in favor of the referendum. However, the federal government made the efforts to resolve this political issue, and two accords were also proposed. One was the Meech Lake Accord in the year 1987, and another was Charlton Accord in the year 1992. But however, these accords were also not finalized, as there was no consensus on all these issues. So meaning thereby, the federal government was in predicament how to resolve this political issue. Finally, in the backdrop of all this, federal government sought a reference from the Supreme Court of Canada to answer three questions. One, whether unilateral secession is possible or permissible under the Canadian Constitution. Second, what is the position under international law? And third, in case there is a conflict of Constitution of Canada and the international law on secession, what is the position? The Supreme Court of Canada did not answer the third question, however answered the first two questions, and held that unilateral secession under the Constitution of Canada is not permissible. So finally, there is one observation given by the Supreme Court of Canada while discussing the whole issue, and developed a term in the shape of effectivity, the principle of effectivity. The principle of effectivity has been in detail explained also by the Supreme Court of Canada by way of observations. You may go through the whole judgment and find out how the Supreme Court of Canada has made the observation qua effectivity. So in nutshell, we can say that under the Constitution of Canada, secession is not permissible. The unilateral act of secession is not permissible. However, if such a resolution is being passed by any province, and then it requires the amendment of the Constitution of Canada as provided under the procedures of amendment, and if those procedures have either of those procedures which are permissible, then the secession is possible. Thank you very much. God bless you.